Thank you, Afshin, for those kind words. So what I want to do is that I'm going to talk about access and benefit sharing, genetic resources, sustainable development and conservation. But because I've always got a lot to say, I'm going to speak really fast. Sadly, I'm tied to the microphone here. I didn't really like to walk around and, talk in pictures. But I'll do my best, and we'll, hopefully make my clear messages. Essentially, what I want to just talk to you and really give you two examples, and I guess talk through perhaps the shady side of the SDGs, and show you that there's we're trying to achieve things that we know don't work. And secondly, is that we're undermining some of the things that we think are good through the SDGs. So I don't want to be all completely cynical and downcast about this. I think the SDGs are generally great, but in the context of access and benefit sharing, I think there are some problems that we probably need to address, and we need to think about different ways of doing things. First of all, thank you really to Matt for organising today. So what I'm going to talk about is the story I want to tell. Is I want to firstly show you what the biodiversity sustainable development goals are that we're going to talk about, and I guess look at the goals and the targets, and just specifically identify the two targets which specifically deal with access and benefit sharing. I then want to give you a whistle-stop tour of the access and benefit sharing, or the ABS schemes, and I guess the conclusion there is that we have these regulatory complexes, but they're not delivering the benefits that we might imagine. And then I want to delve into two problems. The first one is I guess, more of a historical sort of issue. It's to do with the grand bargain that the conventional biological diversity delivered. And what I wanted to do is show you that it hasn't worked. So we've been going for 25 years, it hasn't worked, and yet we're enshrining it again in the SDGs. So I think there's a problem there. The second one I want to talk about is data and information. And this, I guess, comes back to what we were talking about earlier. In the early 1990s, we had this ideal about open access and access to information, and it should be available to all. And what I want to show you is that the current debates in the ABS regime are starting to lock up information, contrary to our ideas about accessible information. So I think that creates a bit of a problem. And then finally, I want to talk about some possible solutions. And I think what's interesting is that Rowena's talk was about this earlier today, is that I want to show you that there are efficient solutions about getting actual quantum of benefits. So we can identify the money, we can get the money. The question then comes is, once you've got the money, how are you going to go about spending it? And that's really what the red problem is, and that's the insights we get. And that's what we'll show you at the end is that there are better ways of collecting money from access and benefit sharing, but that still doesn't resolve how we're going to spend the money. Okay, so looking at the SDGs that are particularly relevant to what we're talking about. Goal 2, it talks about promoting sustainable agriculture. Then the target 2.5, it talks about promote access to and fair and equitable sharing of benefits arising from the utilisation of genetic resources and associated traditional knowledge as internationally agreed. And that's the key point here, is we're talking about as internationally agreed. Then goal 15 talks about halt biodiversity loss, so essentially promoting biodiversity. And the target 15.6, promote fair and equitable sharing of the benefits arising from the utilisation of genetic resources and promote appropriate access to such resources. Interestingly, it doesn't talk about traditional knowledge there, but then again, it's all as internationally agreed. So essentially what we're saying is we're looking at the international arrangements we have in place for access and benefit sharing. We're saying we've got those agreed schemes, and what the Sustainable Development Goals are putting those up as targets to achieve essentially the implementation of those ideals. And what I want to show you is that there's some problems in thinking about it that way. So the way I framed it and the way I think about it is we've got the SDG goals and targets. So our targets are promoting sustainable agriculture and halting biodiversity loss. And the goal we want to get to is we want sustainable agriculture, whatever that might mean, and we want to halt biodiversity conservation. And the mechanism we're applying to get there, so the internationally agreed arrangements, are the access and benefit sharing schemes that we've set out in the legislation. So I think it's a fairly clear mechanism for this particular SDG. So that's not the case for all the SDGs, but for this one, I think that's a clear kind of mechanism we have in place. So essentially what we're doing is we're doing a report card on what the ABS system, what it's like, and can it deliver through the targets to get to the goals. Now, this is going through a bit of history now. Access and benefit sharing has been regulated at the international level for a long, long time. And it's evolved over the time as we've done that. So it really started out with the Antarctic Treaty in 1959, and back in those old days, that's when the decolonialisation was just starting, and we start to have the new emerging nation states. concerned about their resources. That's evolved over time. We've had the Space Treaty, the Law of the Sea Convention in 1982. Now, what's significant about the Law of the Sea Convention is that still in 1982 we thought that the resources of the world were the common heritage of humanity. But that changed with the Convention on Biological Diversity in 1992. We then recognised state sovereignty. I'll come back to that in a moment. The other kind of ABS regulation we've had, and we've had a fairly consistent run of it in recent decades, is the Outer Space Resources Treaty. Essentially that was dealing with, it's hard to believe it, but we were dealing with the genetic resources of outer space. So if you've got a gene out there on Pluto, we have a scheme to organise who owns it and regulate it. Then we had the bond guidelines, voluntary guidelines about how you might identify monetary and non-monetary benefits for sharing. The Plant Treaty in 2004, the Nagoya Protocol in 2010 to give some kind of mechanism to the Convention on Biological Diversity, and most recently the Pandemic Influenza Preparedness Framework to dealing with human influenza viruses. And as we speak here in New York, they're having discussions about developing a new access and benefit sharing scheme for the resources of the high seas. So just to give you a summary, this is the kind of access and benefit sharing schemes that we have applying around the world now. Predominantly, there are some other minor schemes, but these are the main ones. The Convention on Biological Diversity, the CBD, covered by the CBD itself, and also the Nagoya Protocol. We have the Plant Treaty. The Plant Treaty deals with a limited subset of genetic resources or biological things. Then we have the PIP framework, which deals specifically with human influenza virus. So the way this scheme operates is that it applies to everything under the CBD and Nagoya Protocol. Essentially anything biological is covered. We carve out a little bit for the Plant Treaty for particular kinds of agricultural plants. And for the PIP framework, we carve out human influenza viruses of a particular kind. And then we're starting to carve out other mechanisms. We've got one negotiating for the marine resources of the high seas. We're also starting to talk about some microorganisms, and there's some discussion about various forest resources. What do the schemes look like? Essentially, they're all fairly similar. The kind of materials they cover, they're called genetic resources, but that's been applied in a way which essentially covers everything biological. So the CBD, as I say, covers everything. The Plant Treaty covers a limited number of plant materials, which are said to be materials in the multilateral system. Essentially, they're agriculturally important crops, which have been agreed to be within that scheme. And then the PIP framework applies to human pandemic influenza viruses, so very narrow. The way it operates is through these access and benefit sharing, or ABS agreements. Under the CBD, it's a voluntary contract between the conserver and the person who wants access, and they agree to with prior informed consent and mutually agreed terms, they reach an agreement of how much the benefits are going to be. Under the Plant Treaty, it's more streamlined. You've got a standard material transfer agreement. Built into that standard agreement, there is benefit sharing obligations, and the same kind of arrangement under the PIP framework. The kind of benefits we're talking about, under the CBD, it's whatever the parties agree. Under the Plant Treaty, it's a fixed price, standard agreement, it's a fixed price. Interestingly, under the PIP framework, it's also it's slightly different. It's a selection of possible benefits, plus there's a subscription fee. So there's an amount of money you actually have to pay to get access to the human pandemic influenza viruses. So it's three slightly different schemes of what benefits might be. This next slide is really just to show you the ideals we have about information, and really the point I want to make here is that each of these schemes comes with the ideal that any information will be made publicly available. So one of the benefits that's being declared or delivered, and the idea behind these schemes is that the information that's derived from these genetic resources will then be available to the global community, and clearly that's one of the benefits. But the important point, and we'll come back to it later, is that the ideal here is that if you get information from the resources that you've exploited, you make that information available for everybody. And just a final summary slide. This is essentially the model that we're talking about. So we're talking about an economic instrument from the early 1990s. And in the early 1990s, this was the way we thought that was the best way to go about delivering these kinds of benefits. So essentially what you have here is you have a contract. So we meet in the middle between conservers of genetic resources or conservers of biological kinds of things. They come together with the people who are the financiers, the technology owners or whatever. They come together, have a meeting of minds and a contract, and they have some kind of commercial undertaking. They deliver some kind of something commercial, something useful out of what they've exploited from nature with those mutually agreed terms and prior informed consent. And there are benefits that flow from that. The benefits can be monetary benefits, so cash, but they can also be a range of other non-monetary kinds of things. So know-how, scholarships, all sorts of good things that can flow from it. Essentially, the kind of benefits we're talking about here, we can broadly categorise public benefits. They're the things like ecosystem services, economic, social and cultural development. But then we also have the private benefits. And they're the things like trade, intellectual property, those kinds of things. Now, the idea here and the intention of this kind of instrument in the early 1990s is that if you could create some kind of value in biodiversity, you could create, by creating a market, you could then get delivery of some kind of benefits or some kind of value, which would then promote conservation. So that was the model that underpinned what we were talking about then. That's not the way we really look at it now. Really, when we're talking about here, is we're talking about benefits, we're talking about countries which have genetic resources or biological things that the rest of the world wants. They have to have some kind of benefits, and the kind of benefits they're really talking about and thinking about are cash. And I guess this is really the key point about the system. So we've been going from 1992. We're in 2018 now, and we can say that the ABS presently doesn't deliver sufficient benefits. So as a mechanism, it really hasn't worked. Now, don't get me wrong, it has delivered some benefits, and some people have done very well out of it. But as a mechanism for halting biodiversity or transferring wealth or creating markets for biodiversity, it hasn't worked at all. So we can say that ABS has delivered lots of non-monetary benefits, although these are hard to quantify, and they're not the kinds of benefits that most developed countries want. We also need to query whether they're delivering on sustainable agriculture or halting biodiversity loss. And I think we can say that they're neither. I don't think many benefits have actually flowed back to farmers in developing countries, and I don't think there's really had much impact on people saving areas of wild rainforests for the potential drugs that they might have, those sort of things. It hasn't really been a conservation mechanism at all. And I guess the indication of this is that economists stopped really looking at access and benefit sharing in the mid-90s because it just wasn't delivering the kinds of returns or the kinds of economic benefits that was intended. So as an early 1990s economic instrument, I think we can fairly safely say that it hasn't worked at all. So let's move on now and talk about the problems. The first one I want to talk about is this resource sovereignty schism. And really, this is really about the problems of the deal that was done, which was reflected in the Convention on Biological Diversity, which agreed that there should be access in exchange for essentially technology and finances. So up until around 1991, the world generally thought of the resources of the globe as the human heritage the heritage of humankind. And under that kind of ideal, the idea was that essentially the first person to come and take those resources was the person who owned them. So they were really available to the first takers. And you can see that in the agreements like the UN Convention on the Law of the Sea. It still has that ideal built into it. But just before or in the final stages of the negotiation of the Convention on Biological Diversity, we really had this change to nation state. Now, we'd seen echoes of it in the international undertaking and those kinds of arrangements leading up to the Convention on Biological Diversity. So through the 80s, there was this change in idea about which was the best way to recognise these kinds of values. But really, the Convention on Biological Diversity was the first time where we had it in concrete in an international agreement. And what that meant is that the state controlled and regulated the access to those particular resources. So they were no longer available to the first to take. What it meant is the nation state then set the regulation or set the rules for accessing with the idea that they would be able to extract some kind of benefits. Now in the Convention on Biological Diversity, you can actually see the echoes of this grand bargain in the language. So the way I've set up the diagram here is the top left-hand side, we've actually got the previous shape to show you that schism with national state sovereignty. On the top right-hand side is Article 1 of the Convention on Biological Diversity. Essentially, the summary is that breaks into three parts. There are essentially three objectives in the Convention on Biological Diversity, and really I want to point to the third one. And what that shows you is that you have appropriate access to genetic resources, then you have appropriate transfer of relevant technologies, and then you have appropriate funding. And that was the grand bargain. So access, which you have the transfer of genetic resources, so that's the appropriate access to genetic resources from the developing or the poor countries of the world to the rich countries of the world. And in exchange for that, and this was really what drove the conclusion of the CBD, you have technology, including biotechnology, so appropriate transfer of relevant technologies, and also finances, so appropriate funding from the rich countries of the north countries, to the poor and developing countries. And that really is I guess the elements of the grand bargain that's reflected in the CBD. It's a bit contested now whether this actual grand bargain existed. I'd certainly say if you go back to the documents of the time, look at the negotiating documents of the CBD, there's no doubt that we had this shift in the poor countries of the world, the developing south, recognising that if they got sovereignty, it gave them potential access to benefits. And so the deal really was access in exchange for technology transfer and finances. It was recognised at the time, though, that there were some limits to this grand bargain, and I guess this really brings in our intellectual property problem. So hidden in those words in the objective of the CBD in Article 1 is taking into account all rights over those resources and to technologies. And the reason these words were put in there and recognised there is that it's predominantly the non-government sector in the rich countries of the north that own most of the technology. And this was recognising that those resources and the technology are not owned or not controlled by the government. So there's, I guess, an impediment for the governments in agreeing to the CBD to be able to actually mobilise the technology and the resources to the developing south. Interestingly, Indigenous people and pharmaceutical companies were the ones, or were the entities which we recognised had resources and technologies that we might not have had access to, or that governments couldn't necessarily control access to. And I guess the kind of things we had in idea there was that governments couldn't actually deliver that. So we have essentially a failure of the grand bargain. I'm going to have to move along fast here. So just believe me when I say to you is that the problem is the grand bargain has failed. So the SDG, what that means for the SDGs is that we're applying an internationally agreed mechanism which is actually not going to deliver on what we're hoping it's going to deliver. The second one is this definition of genetic resources. Sorry, I've run out of time. This always happens. Too much to say, not enough time. The point I want to make here is that under the global scheme, under the CBD and the Nagoya Protocol, genetic resources, really what we're talking about is physical things, but we're starting to see now, we're having a change, we're starting to look at genetic resources as including the data and information about those resources. The contract models we apply, you have data, a provider, or you have a material transfer provider or a data provider, they give that to the commercialiser sells that to consumer, and then benefits flow back. The problem we have here, the problem in these first two circumstances is you have a legal relationship between the person who accesses the material and the person who delivers the data. The problem we have is when that data goes to third-party users. So we put that information on a publicly available database, goes to a third-party user, they use it, and there's no mechanism, no legal mechanism for delivering benefit sharing back. So it's this problem of third-party use. Now, open accessibility, we were talking about, is slightly more complex. Essentially, we have two sorts of open access. Open accessibility is we have the Libre, which is this idea where you have, we generally call it open source. What it means is you can have access to it, but you have to sign up to some terms and conditions when you access that information. That maintains the legal relationship with the third party. The other one is the Gratis, which is where it's essentially free, unrestricted, and that's the kind of what we would call open access as opposed to open source. It's publicly accessible and unrestricted. The CBD recognises this problem, the Plant Treaty recognises the problem, the PIP framework recognises the problem. This slide is really just to show you is that this is under active consideration. What's happening in these forums, though, is we're recognising that data information is actually much like a physical resource. So we're starting to lock up data and information in the same way that we would lock up physical materials, and requiring a benefit sharing agreement. This is a problem for the SDGs because we assumed when the CBD, the Nagoya Protocol, and the PIP framework were being implemented that the data would be open and accessible. The SDG assumes that it's good to have access to information, those sorts of things. So here what we're doing is we're creating some limitations on how we would have access to that information. And I guess my point is that's probably undermining what we think are going to be the benefits of the SDGs. And I'll leave it there.